Hi, and welcome to the latest of Number 8 Chambers Immigration Law Conversations. The idea of these conversations is just to have a short and hopefully relatively informal chat about current immigration case law and immigration law issues that we're facing as practitioners. Today you've got two of us from Chambers. My name's Alex Barnfield, and with me is Emma Rutherford. And we're going to have a conversation about the civil penalties scheme for illegal work. Workers, the financial penalties that I may have seen from the whole series of these conversations. They're meant to be conversations, they're meant to be informal chats, they're not legal advice, they're not scripted. We are just having a conversation between two of us on this occasion as practitioners with experience of dealing with these types of cases and the issues around them. Yeah, so Emma, nice to see you.
Yes, nice to see you, Alex. So
civil penalties.
Yes, civil penalties. The regime itself has obviously been in for a little while. Can you tell us a little bit more about the regime itself?
Yeah, we were talking about this before, and I mean, to a certain degree, we're going to assume that anybody watching it has some idea of what the scheme is and some knowledge of it. But as a reminder for anybody who is watching, the scheme is a scheme of financial penalties imposed on employers who are found to have employed those without a right to work, illegal workers. The scheme designed to discourage such practices. Whether that is really achieving its aim, I don't know. I don't know how many employers are fully aware of all of it and the requirements. Certainly, compliance with the rules to avoid such an offence and a financial penalty requires employers to have systems in place to check documents, to check the right of work before people start, to have records of those checks, to keep records of the documents that they have checked, and so on. And failing which, certainly, in theory, if those illegal workers were discovered, then the civil penalties scheme would kick in. There are, it's been through various guises, updated over the last decade or so. The position now is that £1,000 is the penalty, maximum penalty to be imposed for one worker for an employer's first incident. For any subsequent incidents, it will be up to £20,000 per worker, which, if there are a number of them, can be very expensive for relatively small businesses, of course. Expensive for any business, but expensive particularly for small businesses, as often they are with the sort of workers that one sees in the cases that we deal with. There are reductions available. That scheme in itself, and I know you're going to perhaps we can come to this later, Emma, in our brief chat, come to exactly how you might deal with appealing, but certainly the substance of an appeal can, of course, be against the imposition of the penalty itself, but also the level, and there's reductions for those within the scheme, whether that's for showing to the Home Office your evidence as an employer of having self-reported the issue. If you report those illegal workers, you're going to benefit from a discount. If you cooperate throughout and with the investigation, if you actually have some systems in place of checking of documents and so on, certainly if you did check the documents, but they proved, for example, or those checks didn't fully assist you, you might have some assistance in a reduction. And but certainly in my experience, I don't know about yours, Emma, but I think pretty generally, the Home Office are pretty accurate in imposing those reductions in the scheme. It's a matter of finding where there are matters that you can appeal and looking for those.
Yes, certainly my experience is appeals are predominantly against the imposition of the penalty rather than the level. The Home Office are usually pretty good about applying the discounts that they can to the penalty that's been imposed. I don't think I've ever seen one that I can think of the top of my head where certainly we've been saying, well, this mitigating factor hasn't been taken into account and it applies.
Yeah. I agree. I think they're very rare. I remember doing one where, as part of the issues of fact that we were dealing with and hearing evidence, it was disputed about the level of cooperation in the end.
Yeah.
The judge sided with the idea that perhaps there had been more cooperation than the employer had been given credit for initially. But I agree, principally, they tend to be either the principal or defences are often what are argued against. And certainly to do that, and perhaps you can come to the procedure in a little while, Emma, but certainly to do that, an objection is the first stage that an employer must go through.
Absolutely.
Sort of in-house appeal, if you like, in-house within the Home Office, raising objections, and certainly my experience of that was working with solicitors and directly with clients is that a well-drafted objection can actually bear some fruit as well. The Home Office, you would hope, are equally keen to avoid going and litigating things unnecessarily. So that objection option must be exercised, and then failing that, or if you're not content with that, and you end up within the county court system under the civil procedure rules and so on, which I know you perhaps can elucidate on further later. But, so yeah, so that's the sort of basis of the scheme as a sort of brief reminder for everybody.
And what types of reasons would people have for appealing, for example, against a penalty?
And I suppose, sorry. Yeah. Yeah, I think there are a number of them, and certainly some of them are very obvious. I mean, the financial penalty itself, as we've said, is £15,000 or up to £20,000, and that is a huge amount of money for small businesses. So obviously the financial penalty itself may be a reason why you might be, as an employer, keen to challenge, if it's possible, the level of that penalty.
Yeah.
The Home Office obviously have records of these things, and it will impact on or in theory it could impact on an employer's future ability to sponsor tier 2 migrants, for example, or to make future applications as a business, and certainly those breaches by employers are publicised by the Home Office. And again, perhaps some people aren't concerned, but for a lot of employers, particularly responsible employers, who may well have legitimate qualms with a penalty that's been imposed, that's a serious thing. You shouldn't have these breaches published if there's actually perhaps good reason for your behaviour or real mitigation or real defence there for you. The impact on your business, as well as future applications and so on, can be more immediate. Certainly they have the power to close the business, I think, on a relatively temporary basis, but they do have that power. And more specifically, for example, businesses which have other licenses granted by local authorities, alcohol licenses and so on, those can be the subject of revocation, and that's a matter that's the High Court has confirmed is the case. The other two things that particularly strike me as obvious reasons why you might want to challenge these purported decisions of the Home Office are that as directors of a company, so if the employer was a limited company with directors, those directors can be disqualified, and of course the whole factual matrix that underlies such a penalty in theory could lead to criminal prosecution as well for knowing or an employer that knew or ought to have been aware that that they were employing an illegal worker. So plenty of reasons why employers, if this was imposed on them, should want to at least look at it and challenge it. And getting, therefore, one would hope, good legal advice promptly may well be important. Is there certainly promptness, it seems to me, is important here, Emma. There are time limits and deadlines on reductions and discounts on penalties as well, aren't there?
Oh, absolutely. I mean, if you take prompt legal advice or investigate your position promptly and see whether there is any defence and discover there isn't, and that you are stuck with this penalty at the level it's at, the sooner you know that, the better, because the Home Office operates a scheme where if you pay in full within 21 days, you actually get a 30% discount on the fine. Now, that's obviously quite a significant amount. If you've got a £10,000 fine, that's £3,000 you're saving yourself. You don't want to throw good money after bad. Why give the Home Office £10,000 if you can give them 7, for example, by taking that prompt advice? And of course, there are time limits when it comes to lodging any objection that you wish to lodge with the Home Office. Just moving slightly on to procedure. You've obviously got, when you get the notice, you get told you've got 28 days to object, and there's no power to extend that. The Home Office don't want to look kindly on, particularly on late applications, and they make it very, very clear in the notice what the date is. It's always worth checking that the date is right, but you've only got the 28 days. Yeah. And as we've observed already, as you've observed already, Alex, it's important that that objection's lodged, because if you don't lodge that objection, you can't, in most cases, lodge an appeal. The only exception to that rule is where you've already lodged an objection and the Home Office have in fact realised that they've imposed the wrong level of fine, so they've given you the benefit of a mitigating factor that they shouldn't have done and increased your fine. It's only in those circumstances you can say, well, actually, I'm not going to lodge another objection, I'm just going to appeal. You can lodge another objection if you think there's been an error, and you may want to do so because it avoids costs, because of course as soon as you start going down the route of lodging appeals, you start incurring not only your own costs, but laying yourself open potentially to costs for the Home Office as well if you're unsuccessful in your appeal. Another reason to try and avoid taking unmeritorious applications, because you're just increasing your costs in those circumstances. But coming back to the procedure, obviously you must make your objection. It's to be done in writing, and of course we'd always advise to give the most detailed explanation you can. At this stage, of course, you won't know what the Home Office evidence is. You just have their statement of facts that you've employed X person who's not lawfully entitled to work in the UK. You certainly won't get witness statements and evidence to back up what they're saying that this person was not lawfully allowed to work.
And the classic example being that you almost at this stage almost never see the any interviews, for example.
No,
you don't know you might not know if you're representing what your client has said. You won't have a record of it anyway, other than their instructions of what they told you they've said.
And of course, what you also may not have is any idea what in fact was said by the illegal immigrants, if they are in fact illegal immigrants, and what they've said about matters such as how much they're being paid, how many hours they're working, things that, may help.
Where they live, that sort of thing.
Yeah, things that may point one way or another as to the employer's knowledge of the status of this person, and making it even more difficult to appeal or easier to appeal, because you can say, well, look, I obviously didn't know, not that's a defence, but those interviews can be quite damning, and you don't always get the full transcript at this stage, but very rarely get at that stage. And you're to one stage at this point, you've got your one hand tied behind your back because you don't know what the Home Office have got entirely. You don't know what their full evidence is. But once you've lodged your objection, and if it's refused by the Home Office, and the Home Office, of course, can refuse to maintain the penalty, they can reduce the penalty, they can cancel the penalty, or they can increase the penalty. I have to say, I've never seen one increase, but they do, of course, have that power. But if you're dissatisfied with the response from the Home Office, you can, of course, appeal to the County Court. It's Form N161. The form doesn't make a great deal of sense when you're filling it out, because it talks about appealing from a decision from a district judge, but it is the right form. you need to obviously file that at court and pay the appropriate fee. It's currently £140, but obviously court fees change regularly. And then the appeal will make its way through the system. The Home Office will be given an opportunity to respond to what you say. You will get directions from the tribunal regarding the filing of evidence, the filing of skeleton arguments. I always think in these cases skeleton arguments are helpful, because although the civil procedure rules suggest that you don't need to do skeleton arguments unless it really will help the court, the judge is likely to be unfamiliar with this area of law. It's not something they deal with a huge amount, because a lot of these cases do resolve themselves. And I think a skeleton argument always helps the judge in any event, even if they're reasonably familiar with the law, to work their way through the evidence and what you're actually saying. Important point to note, though, the civil procedure rules do apply. And of course, in appeals under the civil procedure rules, you can only call live evidence with the permission of the court. So if you're going to want to call the employer to give evidence or any witnesses in support, you can't just do that. You do need the permission of the court. So you do need to make sure that you get a direction permitting you to do that. And I don't know about your experience, Alex, but certainly mine is that in the vast, vast majority of cases, if you've got any hope of succeeding, you need your witnesses to give evidence and the appellant to give evidence in order to say, well, this is what I did, this is what I knew, I wasn't employing this person. It's only going to be if you've got a technical issue, really, where you're not going to want to call evidence.
I think that's right. I think it's in the same way as a lot of our experience in the tribunal is. If the issue is basically a credibility issue, then you better have some evidence to back up your credibility debate. So yeah, I agree. They tend to be factual issues, and they therefore tend to need factual evidence.
Yeah, and I don't know about you, but the types of issues that we frequently see tend to often revolve around, was this person actually employed by the employer? Yeah. Now, a lot of the time, as we've already indicated, the interviews are normally quite unhelpful there, or can be quite unhelpful, but it's not always the case that the Home Office have got it right. I've certainly done cases where the Home Office were asserting that my client was employing somebody who was an illegal immigrant, and we were saying, hang on, this person's got a spouse visa and entitled to work, and here's the spouse visa. They'd got the wrong person. They were accusing us of employing someone completely different. It was a very common surname, but they got it completely wrong, and in the end they had to concede that. It took a while, but they did eventually concede that we had employed somebody who was lawfully entitled to work there. I think it was a tip-off rather than a raid, so there were no interviews, but it was bad on the part of the Home Office how long it did take to identify that it was the wrong person. But people make mistakes, and mistakes happen. So it's always important to check that point. Other points that often arise relate to, is the person actually employed by the person the civil penalty notice is issued against? This can get into technical issues of employment law, which is probably more your area of expertise than mine, but is the person employed, or is the person a self-employed contractor? Is the person employed through an agency? Or
or which limited company is the who's employing who, and all those issues are often live.
So that's often quite, and it can often be a little bit tricky, looking at the actual employer-employee relationship and whether it is a contract of service or a contract for services between them. So sometimes it's not just a straightforward, I've got no idea who this person is, or he was a friend and he was just at my premises, which is quite often run as a defence. Sometimes you have more technical defences about the actual nature of who's employing the employee, which are often ones where you do need to think quite carefully about the evidence that you need there and the legal arguments that can be put forward. The other big area, of course, where people run defences is that they have a statutory excuse, which is provided for under the regime. So where somebody has undertaken the appropriate checks, but has not inadvertently employed someone who's illegally here. And they say, well, hang on, this isn't fair. I did the checks. Here's all the evidence I've done the checks. And the law recognises that you shouldn't, in those circumstances, as an employer, be penalised, because there will be people who do try and pull the wool over employers' eyes saying, look, I've got a right to work here, here's my passport, when it's a false passport. There are some things that you do really need to make sure that you're doing properly to avoid being in this situation, because I often find that this is legitimate employers who just get caught out, and the big thing they don't do is do the checks properly and record that they've done them. And I don't know whether you find that, but a number of times I've had to say to people, I'm really sorry, but you have no statutory excuse here because you didn't record when you undertook the check. Obviously, you've got to make sure that the documents are, that the document relates to the person in front of you. I mean, normally you have to do the document check in front with the person present. Obviously, with current circumstances with COVID-19, that's been suspended. But it's so important to take a copy, record when you did it, and just do basic checks on that document. Does the person look like the person in the photograph? Do the details match up with what you're being told? And if they do, and you properly record the check, then you do have a statutory excuse there and can avoid a penalty. One of the just little pitfall that sometimes little, but pitfall that people fall into is there are some people who obviously are here lawfully for a set period of time. So they're here as a spouse for 2.5 years. They're here as a student. They're allowed to work for a period of their visa. That's a time-limited statutory excuse. You have to make sure you note down and keep a record of when you need to redo that check to ensure they're continuing right to work. Because the statutory excuse in those circumstances is limited to the time period when the leave was valid, which you initially checked. So it's always important to keep your records carefully there as well. And of course, if you've done that and you can produce those records, you've got a statutory excuse which you can use if the Home Office erroneously issue a civil penalty to you, even though you've employed someone illegally. If you've conducted those checks properly, then you've got a defence that you can deploy in the county court and as part of the objection process.
No, I think that's a pretty good summary of the sorts of things that we come across. Unless there's anything else that you think is useful, that's probably a helpful introduction, really.
I think so. I can't think of anything else unless you can, Alex.
No, I hope that's a useful summary for people, really, and hopefully it gives people in the position of either being employers or people watching this who know of people who've got these penalties and are thinking about these issues. It gives them some food for thought as to why there probably are or potentially are some valid challenges that can be made, and why it's worth objecting and appealing if there are those grounds available. So thanks Emma very much.
And thank you, Alex.
Thank you for tuning into these conversations. As I said at the start, there's a whole series of these that have been produced by chambers on a variety of topics, which we hope are useful and relatively informative and relaxed for you. And you can find more information about those on our website or our Twitter account, and follow us there for more of these immigration law conversations. And I hope that lockdown and everybody's well-being is improved soon, and stay safe, everybody. See you later, Emma. Bye.
See you soon, Alex. Thanks.
Cheers.